Your Honor, this is going to be a plea to the bench.
All right.
And I've got an executed plea agreement. Ms. Leon has signed it as well. And I have a copy of the score sheet, which I've gone over, and I have no objection.
All right.
You all right? Yep. Your Honor,
This is
it's a
an open plea, no agreement.
Pardon me?
Open plea, no agreement.
That's correct.
Yes, sir.
All right, raise your right hand, please.
Sorry?
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, you put your hand down. Now, Mr. Swiatek has tendered to me a plea agreement that claims to have your signature on it. Did you sign this plea agreement?
Yes, Your Honor.
How old are you?
22.
How much school do you have?
Junior high.
All right, you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes.
All right, according to this plea agreement, you're pleading no contest to the announced charges. Do you understand that?
Yes, sir.
And that says to me that you believe if you went to trial, the state has the evidence necessary to convince the jury of your guilt, and you're not going to contest that.
Yes, Your Honor.
Do you understand by making this plea, you're waiving your right to a trial by jury, where the state would have to present that evidence to the jury and convince the jury beyond a reasonable doubt of your guilt of these charges?
Yes, Your Honor.
Do you understand by this plea arrangement that there is no agreement regarding your sentence?
Yes, Your Honor.
What does that mean?
Can you repeat it one more time?
Say again?
Can you repeat it one more time?
Yes, sir. There's no agreement regarding what sentence you'll be given. Do you understand that? All right. Do you understand that?
Yeah.
What does that mean?
You can sentence me to whatever pretty much you're giving me, whatever you want to give me.
Okay, and
Yeah.
so what is the maximum possible sentence you could receive?
50 years?
In the Department of Corrections on,
Yes.
based upon counts 1 through 7, 5 years each, and count A to 15 years, correct?
Yes, sir. Yep.
And you understand, based upon the score sheet Mr. Swiatek has given me, that is presumed or believed that based upon your score sheet, you're going to serve a minimum of 50 months in the Department of Corrections.
Yes.
Now, Mr. Swiatek, is it your intention to request a sentencing hearing?
Yes, Your Honor.
And are you intending to seek a departure?
Yes, sir.
Okay. So, Mr. Swiatek will have a hearing where he intends to present evidence to try and convince me that I legally can give you something less than the 50 months, and that it's appropriate for me to do so. Do you understand that?
Yes, sir.
It's one of the few times the defendant has to prove anything, but it's your burden to do that. Otherwise, you'll be facing that minimum sentence. Do you understand?
Yes, sir.
All right. Mr. Swiatek, considering what the sentence you're facing, why are you making this choice to make the plea instead of going to trial and forcing the state to prove your guilt?
Best interest?
Okay? Magic words a judge likes to hear. Tell me why it's better for you to make this plea instead of going to trial. Why is this a better choice?
Too risky?
Okay. All right. Well, it's an open plea. So how is it more risky to go to trial than to make an open plea where you could still get 50 years? Has somebody told you that if you go to trial or something that I'll punish you? You'll get a worse sentence if you go to trial in front of me?
They said it wasn't ideal.
Say again?
It wasn't ideal.
It wasn't ideal.
Yeah. It was just best for me to sign the plea to the bench.
Okay. All right, now, I don't want you to tell me what your lawyer specifically said, the advice your lawyer gave you, but did your lawyer say something like this? Right now, the judge doesn't know a whole lot about this case. The judge only knows what's in the court file. But if you go to trial, the judge is likely to know a whole lot more, and that may change the judge's view of how to sentence you. Is it maybe something like that?
Yes, sir.
Okay. So based upon that, that's why we made the decision to do this. All right. Because you would rather have Mr. Switek give the opportunity to argue what an appropriate sentence is, as opposed to go to trial and have me hear all of the details.
Yes.
Okay. All right. Has Mr. Switek answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with how he's represented you?
Yes.
The court will find the plea to be freely and voluntarily entered into with the knowledge of the potential outcome of the sentence and the fact that it's an open plea to the court. I'll tender the score sheet back to be held until we have the sentencing. How much time is the defendant entitled to a PSI, or is that being waived?
That's a waived, Your Honor.
All right, PSI is waived. How much time do you think you need to be ready for your sentencing hearing?
Well, I also have another case, Mr. Rubens, today, that's going to be an open plea, and we'd like to have him on the same day, sometime in August.
Okay, Madam Clerk?
We have August 13th at 2 p.m. or August 20th at 2 p.m.
Probably if you're ordering, the judge is going to order the PSI the 20th, so we give enough time to
Well, we're
probation.
not ordering PSI on Mr. Escone because that's being waived.
No, I know, yeah, but Mr. Switek said that he would like to have another sentencing that would require a PSI on the same day.
Oh, okay.
Yes.
Mr. Rubens required a PSI.
Yes.
Yes.
So 20 August,
That'll be fine.
20 August, 2 o'clock.
Thank you.
All right, thank you.
Your Honor, my next case is Lyle Rubens, 22 CF 2311.
And Mr. McCoy, I see you're still on the connection. You're free to go at this point in time, sir.
Thank you, Your Honor. Anyway, this is an open plea to the bench in Mr. Rubens' case, 22 CF 2311, if I may approach.
Granted.
And I've similarly examined the score sheet and do not have an objection. Okay, thanks.
All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Do the best I can.
You want a second, Mr. Switek?
Yes.
Okay. Now, is there something going on I should know about that affects your ability to know and understand what's going on here today?
Your Honor, Mr. Rubens presents with mental health issues. He has been committed to Florida State Hospital twice during the pendency of this case. I've talked to him extensively. I do believe he's competent to proceed, but it will be difficult to get through.
Okay, so what you're telling the court is this is the way he presents, and given the fact that we're in an open courtroom, this may present some stress factors for him which would affect his ability to engage with the court?
Yes, sir.
Okay. All right. So, Mr. Rubens, if you need another minute, just slow down, and I'll be happy to let you talk to Mr. Switek so he can help you get the questions answered, okay? You know, you've been sworn to tell the truth. Were you willing to do that today?
Yes.
Okay. Now, Mr. Switek has given me a written plea agreement which claims to have your signature on that. Did you sign that?
I have a bad memory, but I guess I did. I have to see my signature to make
All
sure.
right, well, I'll hand it back and let Mr. Switek walk through it with you, okay?
Is that your
Yes,
signature?
that is it.
No. With your bad memory, I'm going to let him keep that plea agreement right there so you can go over that. Does your bad memory affect your ability, you think, to be able to go through this plea agreement with me now and make meaningful answers to it? Or you just need a little more time to have Mr. Switek help you?
I'm not quite sure.
Okay, well, we'll go as best we can, and we'll see how far we can get, okay?
Okay,
All right? And so now you've seen that you signed the plea agreement, right?
yes,
All right? How old are you?
29.
All right? And how much school did you end up having?
High school diploma,
Okay.
I got that.
All right? Now,
But however, I had like Fs my whole school career. And I've never put in special ed, but that probably would have been an option if we would have figured that out.
okay. All right. You able to read and understand the plea form?
Yes,
Okay. And did you do that before you signed it? Is it yes?
Yes.
Okay. And did Mr. Switek help you answer any questions that you may have had about the contents of the plea form?
I'm not sure.
Okay. Do you want a minute now to go over it with him?
No, yeah, I remember, I think, let's see.
We talked about your exposure, right?
Yes, I saw this.
Okay. Well, counsel, if you'd approach.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just one block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Okay, we're going to do this at I'm going to check mine just to be double sure. How about July the 2nd, Ms. Natalie says?
July the 2nd?
Yes.
1 second.
I'm open all day.
All right, what time, July the 2nd, Ms. Natalie? $12:30.
Yes, sir.
All right, so 7 to at 12:30. All right?
7-2.
All right, very good. Thank you now. Good day.
Thank you very much, Your Honor.
Is that it for you today, Mr. Schweitzer?
That's it for me.
Okay. All right, Ms. Jaquith, if you're prepared,
Yes, sir, I am.
all right.
Your Honor, the only case I have on the docket,
Mr. Watucky, right?
Mr. Watucky, yes, sir. And, Mr. Watucky, if you recall, is the gentleman who we sent back to Walton County. And so I left him on for today's purposes because pursuant to an agreement made with the state attorney's office, we need to allow the court to revoke his bond. And he obviously is not there because he's still in Walton County Jail.
All right.
And I apologize, that case number is 24 CF 2710.
All right. Bond is revoked. Well, I guess we is issuing a bond capias, right?
Yes, Your Honor. And then as far as his case, does the court wish to keep it tracking on the docket or allow it to kind of fall off until he's back?
Ordinarily, with the bond capias, it'd fall off, but I'd like to set it for status because I don't want it just to sit there and...
Agreed, Your Honor.
So you want to put it...
I was going to ask for...
I'm sorry.
I was going to ask for the 23rd.
All right, 7/23.
Yes, sir.
All right. State?
Thank you, Your Honor.
No objection.
All right, so it'll be status on 7/23.
Perfect. Thank you, Your Honor. I appreciate the accommodations this morning.
You're welcome, ma'am. I hope you feel better.
Thank you.
Good day.
I also have a Tammy Moore, just Ms. Jaquith.
Ms. Jacob, did you hear that? You have Tammy Moore as well?
That was continued by order, Your Honor, to the 7/23 at 2 p.m.
Okay. All right, thank you now.
Thank you.
All right, Mr. Cotton.
Good morning, Your Honor.
Good morning, Mr. Cotton.
I've got the Baron Smith on the docket. Judge, if I could have about 30 seconds.
Yes, sir.
Judge, I appreciate the time. Thank you.
You're welcome, sir.
Your Honor, for the record, Byron Cotton, present with the Baron Smith in case numbers 26CF0061, 21CF1470, and 19CF431. Your Honor, I just received discovery on this case and filed on this case. I'm taking it over. I believe it had been with the public defender. I've spoken with my client and updated him briefly on a plan for moving forward. I also spoke with the state and requested a continuance to be able to review the discovery in this matter, meet with my client and prepare. I do not believe she has an objection to a continuance.
No, that's correct, Your Honor.
At this time, we request a continuance so that I can prepare for the hearings.
All right, and my notes indicate the state previously made an offer. I don't know if you're privy to the offer the state made.
I am not.
I'll put this noise on so you can get over there and understand what that is right now for the benefit of your client.
Thank you, Judge. I did not get the exact offer, but it is my understanding it's a DOC sentence. My client is not in a position to accept that today. I don't believe the state's intending to revoke that. They're going to let me have some time to review the file.
That's correct, Your Honor.
Well, I think my notes indicate there's a 60-month Department of Corrections suspended sentence
I've seen that.
in the VOP.
Yes, sir.
And the state had agreed that that would resolve all of the matters, including the new charges.
Yeah,
That's
Judge,
correct, yes, Your Honor. Thank you.
Yes, I'm sorry, I didn't mean to interrupt. Thank you for relaying that. Judge, I'm not in a position to advise my client to accept that today without the ability to review the file. At this time, I'd request a continuance on the case in order to be able to prepare to determine how best to proceed in this case and consult with my client.
All right? State?
No objection, Your Honor.
All right, with or without subpoenas?
Without.
Subpoena.
Okay. What date are you looking at?
May I have just one more second?
Yes.
All right. Thank you, Your Honor. In reviewing the reports, the state did provide me or forward me some written discovery on this case. Based on my review of that discovery, there may be some body camera interview that I believe would be relevant. Ms. Leone indicated she would check her file for that also.
Yes.
So obviously, if there is that, I would need time to review that. There are also some potential witnesses I'll need to speak with. So I'm not sure what the court's continuance cycle looks like. If you could give me a couple of dates, I might be able to be.
Well, we got 7/16, 7/23, and then we got 8.
The first date in August would be August 13th,
8/13, and then
8/20.
8/20.
Judge, obviously, this docket, because of what it is, moves more quickly sometimes than the other docket. So I think if I could have, was that first date 7/15?
13.
7/13?
16, sorry.
7/16?
Yeah, 7/13 is the pre-trial, 7/16 is your miscellaneous day.
Okay. Your Honor, right now, if I could take just the sooner, because obviously if I can get this ready, and if I need more time at that time after
Yes, sir.
some investigation,
Yes,
but
sir.
that'll give me time to.
7/16, no subs. That'll be 9 o'clock.
7/16, no subs at 9 a.m.?
Yes, sir.
Thank you.
That's all I have, Your Honor.
All right, thank you, good day.
Thank you, Judge.
Mr. Weinstock.
You're welcome.
Your Honor, I have two cases in front of you today. Hi. Sir, this is James Arthur Prelowitz on case 24 CF 178. I have next week, on June 18th, I have a motion for a bond reduction. And then subsequently, on July 16th, I have a motion to take depositions on there. So I'm going to request a continuance on this case.
All right, you have depositions already set, is what you're saying?
No, sir, I need your permission to take deposition of the minor.
Okay.
Yes, Your Honor, the hearing on that motion is set currently for July 16th.
All right, so we already have things set,
Yes, yes, Your Honor.
and we were here today for,
Well, the previous attorney questioned his competency. He was examined by Randy McDonald. She claimed that he was competent to proceed, and I believe we need your review of that and your determination that he is competent to proceed. Why? I'll go through it, probably.
actually, I think it's the other way. If the report had found him not competent, that I would make that determination, but the report says he's competent, so I don't think there's any action for the court to take if the report says that he's competent.
All right. We do have to set a date subsequent perhaps to July 16th.
Well, if you've already got things set,
Sir?
you already have 2 hearings set. You have a bond motion and you have the deposition, so I don't think we need to set anything further at this time.
All right, Your Honor, then I'll see you on on June 18th for a bond hearing.
All right, very good.
All right, thank you. Thank you. I'll catch you this weekend, hopefully. Okay, give me all the information. Your Honor, the second case I have is State of Florida versus Harley Nicole Faison, 24C 2051.
2051.
Yes, sir.
All right.
I have not had contact with my client. I was advised by my staff that she wasn't notified yesterday. Oh. It's first
Do you
time.
need a minute?
First time I met.
Talk to your client. I'll turn the noise on so you can.
Okay, well, Your Honor, at this point right now, because I did not have a chance to talk to her before, I'd like to ask for continuance.
All right, well, why don't you step outside and just make the connection and then come back and tell me what we're going to do, okay?
Your Honor, yeah.
Ms. Sutherland.
Good morning, Judge.
Good morning, Ms. Sutherland.
Jared Sutherland here on behalf of Mr. Theodore Mel. This is case number 25CF 450. We were here for a control date for me to provide a certificate to the court. I've filed that electronically with the court and sent it to the prosecutor. I also have a copy with me if you'd like me to approach.
Granted. Thank you.
And based on the certificate provided to the court, I'd ask that the court vacate the sentence in this case.
Say again?
I'd ask that the court vacate the sentence in this case that was to be imposed due to the inability of my client to serve that sentence.
Stay?
No objection, Your Honor.
All right. All right, sentence is vacated.
Thank you, Judge. That's all I have.
Thank you. Good day.
You too.
Mr. Dees.
Good morning, Your Honor.
Good morning, Mr. Dees.
Your Honor, I have Charles Richard Pope with me this morning. It's 26CF207. Your Honor, we've reached an agreement in Mr. Pope's case. I believe everybody has executed the plea and sentencing agreement. May I approach?
Granted.
Together with the score sheet. No objection to the score sheet.
Thanks. Please shoot, sir.
Judge, if you'd like me to announce the terms.
Please do.
The agreement with the State Attorney's Office is a withhold adjudication. He'll be placed on probation for 2 years. Community control for 2 years, followed by 24 months of probation as well. Cost of that is $40 a month. Fines and costs in this case are $1,140. He'll have 48 hours of community service work to perform, and he'll be subject to random ear analysis. Count 2 would be an adjudication of guilt credit for time served on the misdemeanor.
Is that the state's agreement? Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, you put your hand down. You heard what Mr. Dees said, and you signed the written plea form.
Yes, sir.
How old are you?
61.
How much school do you have?
I'm a high school graduate.
All right. You able to read and understand the plea form?
Yes, Your Honor.
And did you do that before you signed it?
Yes, sir.
And it's what you read, what Mr. Dees just announced to me.
Yes, Your Honor.
You understand by this plea arrangement that you're pleading no contest to the announced charges?
Yes, sir.
And that tells me you think the state could prove your guilt to the jury and you're not going to contest that?
Correct.
And by doing this, you understand you're waiving the right to that trial where the state would have to prove your guilt.
Yes, sir.
And in this case, adjudication will be withheld on count 1, you'll be adjudicated on count 2, you'll be sentenced 2 years community control, followed by another 2 years of probation with the fees and costs that were announced.
Yes, I understand, Your Honor.
Mr. D's answered all your questions?
Yes, sir.
You're satisfied with how he's represented you?
Very much.
All right, the court will find the plea to be freely and voluntarily entered into and will accept the plea.
Thank you, Your Honor.
Thank you. Thank you, good day.
Leave probation may need to see you over there.
Mr. Riasti.
You've seen Jeff.
See you later, Mr. D. Safe journey home.
Thank you.
Good morning, Your Honor.
Good morning, sir.
Joseph Riasti for Raul Alfredo Mila Jr., who's present over the court in 4 cases, 2023 CF 1501, 2023 CF 2492, 2023 CF 2493, 2023 CF 2513. Your Honor, this case was set for status, and after speaking with Mr. Gomez extensively about possibility of, and my client, about the possibility of entering a plea, we'd like to set the case for the miscellaneous day that you have, if possible. Do you still have room in that docket?
Next week?
Yes.
Yes.
I'd
But
like to set
we're
the
going
case.
forward to trial on 7/13.
Yes, Your Honor. And so I'd like to set the case for a plea or continuance on that date.
But it won't be a continuance, it'll be plea or trial on 7/13.
Yes, Your Honor. But we have pretrial set on the 13th, I think. The case is set for pretrial on the 13th.
Correct.
And this would be an open plea, there's no, actually, the state has extended an offer to Mr. Mila that will expire on the 18th. It's a 25-year offer with no probation to follow, but with sex offender status afterwards. And I'll be discussing the terms of that offer and the consequences of an open plea with Mr. Mila. And he's expressed at least he's on the fence right now. He wants to talk to his family, but he's discussed entering a plea, and he understands that the differences between presenting defenses at trial and mitigation arguments at sentencing, and we've gone over the score sheet. Although we have a new score sheet here that's just been worked out.
Because that's based upon the state's intentions regarding filing and changing the nature of the charge.
Yes, Your Honor. And so I have the score sheet that I have right now is the score sheet I believe I would be handing in for either a plea to the 25-year offer or a plea to an open plea to the court. Okay. And so we finalized the bottom of the guidelines and the max for an open plea and the offer. And all of those terms are before Mr. Mila right now, and we're asking the court to set this case on the 18th so that he has at least a time between now and then to consider the plea, knowing that the state will be withdrawing its offer on the 18th.
That's correct, I think just to put it a little less, we want another opportunity for him to enter a plea before the pre-trial date. He's well aware, and I've spoken with Mr. Riasti, that
use the microphone.
This is it. Yes, ma'am, I'll let him know.
He is well aware that we are going towards trial. We just want to provide every opportunity to enter a plea if that is what he so chooses to do before that pre-trial date, because we know it is a busy date. And so our offer, the 25-year offer, will expire if not accepted on June 18th, Your Honor.
All right, so the possible change of plea on 6/18. After that, the state going to revoke their offer, is that it? Would it be an open plea to the court?
That's correct, Your Honor.
Okay. All right, we'll see you on 6/18, 9 o'clock.
Thank you, Your Honor.
Mr. Viasti?
No, Your Honor, that's all I have.
All right, thank you, good day. Mr. Stewart?
Good morning, Your Honor.
Good morning, Mr. Stewart.
May it please the court, Your Honor, Brad Stewart on behalf of Holly Martin. This is cases 25 CF 1019 and 1029, Your Honor. May the state not approach.
Granted.
Your Honor, I'd like to move Ms. Martin's case to next Thursday, if we may, at 9 a.m.
All right. Change of plea on 6/18.
Your Honor, that's all I have before the court, may be excused.
Yes, sir, good day.
Thank you, Your Honor.
All right, Mr. Notes, or Mr. Weinstock, you ready?
Yes, Your Honor.
With Ms. Faison, all right?
Is it Haley Mason?
You had a chance to chat with your client now.
Yes, I have.
Good.
It's very illuminating, Your Honor. Right now, we're here because the state is alleging that she's violated the pretrial intervention program, and we'd like to argue against that. She claims she has 4 months left to go on that program, so we're asking the court to put her back on that for the 4 months.
All right, did you talk to the state about this?
I haven't had the opportunity. I just came in from the outside.
Okay.
State?
State?
Your Honor, I'm covering for ASA Snell. At this time, I wouldn't be able to agree to put her back on to the PTI program. The current offer that I've been authorized to give would be a withhold of 3 years of probation, substance abuse evaluation, and your treatment recommended.
I'd like to have a hearing on this matter, Your Honor.
Well, and maybe if Mr. Snell's here can review the documents or information that your client's just given you, maybe that could change. Mr. Gomez is sitting in for Mr. Snell, and he'd be in a position. So you want to set it for next week?
The state's amenable to that, Your Honor, and I'll make notes from Mr.
And
Snell.
then if you can resolve it in between then and now, then, we'll move it to another date if that works. Otherwise, we'll put it on for next week. Will that work for you?
The 18th, Your Honor?
But I'm also talking to your client because she had a big question mark on her face about next week.
I just have court-ordered visitation with my children on Mondays.
Okay, the 18th.
That would be Thursday.
Okay.
Right, because I remember that, when I think the state asked for Capias, and I said no, because I'm not going to make her choose between following 2 different court orders. So, but talk with your client about that, because, our docket days and pre-trials and everything are generally Mondays.
Agree to the 18th?
Yeah, that's fine.
Okay, all right, so the 18th at 9 o'clock, get in touch with Mr. Snell and take care of business, okay?
If you can make sure to get that documentation to Mr. Snell as soon as possible so that he can have a conversation.
That's all I have, Your Honor.
All right, thank you, Mr. Weinstock, good day.
Good day, sir.
All right, Mr. Lopez. How are you today?
I'm doing well, Judge. How are you?
I'm good, thank you.
Judge, first case I've got is Stephen Andrew Brewster.
And there's several case numbers, 24 CF 1650, 24 CF 1651, 24 CF 1862, 25 CF 1548. Judge, I think that it's a status, but the reality is that I think he's been declared incompetent, and I don't know that there's been anything sent by any of the people that's interviewing him and helping him to indicate that that's changed.
Judge, I have an emergency. I'm being denied my right to report homicide at the jail, and I know where 4 infant babies' bodies are buried. And this ain't no incompetent stuff, this is real facts. On the penalty of perjury, I declare on the penalty of perjury that all facts stated right now is true and correct. I know where 4 infant bodies are buried, and I'm being denied my right to report it to the sheriff.
Well, it's on the record now, and the sheriff is present, and they'll take appropriate action as they see need.
This is also related to XXX families that I've already reported to the jail. Facebook.
And Mr. Nopes, I'm looking at the report from FSH at docket ID 177 on 413, and they declare the defendant able to proceed.
What's the date of that, Judge?
4/13 of 26 is when it was filed. The report is dated 4/8.
We are the CIAs.
I'm sorry. And it concludes with, he's able to state his charges, has full appreciation of the possible penalties, his knowledge of the legal process is acceptable, and he has sufficient present ability to consult with his counsel with a reasonable degree of rational understanding and to testify truthfully. And that he manages his behavior appropriately in the current setting is expected and would exhibit appropriate behavior in the courtroom. Accordingly, it is recommended he be returned to the jurisdiction for disposition.
Judge, you know, I'm on the email list. I don't know why that didn't get to me, but...
I don't think it actually, I see the order to transport, and...
Judge, if I may say so, also the state attorney's office has 25 employees. The public defender's office has 15 employees. This is an emergency also. Along with 27 employees who work at the jail, who are my nieces and nephews' predecessor for a child molestation ring related to XXX families on Facebook. So, in other words, also you have FBI warrants as well for sexual assault or sexual battery on minors.
And the defendant also filed pro se documents on 6/1 at DIN 980 where he recites these same facts and circumstances.
Okay. Judge, may we approach?
Granted.
State law.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street.
Name Alfred Hitchcock, Judge Stone.
What date are we going? We'll continue the matter to 8:20. And you'll submit your order, Mr. Nopes. Yes, sir. Okay. Thank you very much. Good day, sir.
Yes, sir. Enjoy your life sentence later on.
You said the 2698 case is being transferred?
That's a challenge.
Yes.
That work here.
It was 8:20, isn't it?
Hey, look it up.
8:20.
The second date in August?
Yeah.
Yes, sure.
Okay. And he thinks it's not, but what is the correct case number?
Yes, sir, 26 CF 938.
No, it is 26 CF 938, Mr. Nopes. Do you just want to order tennis moved for the transfer, Mr. Gomez?
Yes, Your Honor, we would order tennis move 26 CF 938 into, or to the south, Your Honor, into this division as we have all of the other open cases with this.
No objection. All right, the court grants order tennis motion transfer 26 CF 938 out of, is that 6?
Yes, Your Honor.
Out of Division 6 into Division 2.
Judge, I got one more case, and I don't expect it to be as colorful, but 23 CF 1941, Dana Nelson, Melson. There was a report filed June 9th that said that she was still incompetent to proceed.
And it also stated, Your Honor, just for the record, that they do believe there is a chance that she will be restorable within the next 6 months, just so that we're not in like a limbo of having no idea. It did state that they believe she could be restorable within that period of time.
All right, well, let's set a status date about 6 months out, Madam Clerk.
You're looking for dates in December, Your Honor? The first day would be December 17th.
12/17.
Wow. Well, we'll just go to January, so I've done. Y'all have a great day. Thank you, Judge.
All right, thank you, Mr. Nopes. That's it for you today? I thought you had something else. Is that for Mr. Nopes?
That's all I want you to do.
That's all I have, Mr. Nopes, Your Honor.
Okay, all right.
Thank you, Judge.
All right. All right. I've got, Caden Stewart. All right, I believe this state that Mr. Stewart has no attorney. I believe we were here for the paying of the restitution, right, to Buddies. And I think we told him if it was squared away, that he didn't need to be here. And so I don't know what's going on.
According to the notes from ASA Snell, Your Honor, it would be a request to continue this, it would be a joint continuance. He is still trying to figure out where to send the restitution to, as the victim / business sold the business to a new company.
Okay. 7, first time in July?
July 16th, Your Honor.
7/16. Samuel Strength.
Good morning, Your Honor.
Good morning. You're here today without an attorney. Do you want an attorney to help you?
Yes, please.
You able to afford one on your own?
Negative.
All right. You'll be given the application, fill that out, turn it back into the bailiff. Don't leave until you turn your application in and get a new court date, okay?
Sure thing. Yes, thank you.
All right. Demetrius Rudolph.
Good morning.
Good morning. You've been here a couple of times. I think we were looking at you didn't take care of your community service hours, right?
Yes, sir. I haven't completed them, but I have started.
Okay. All right. State you wish to give me a little more time to complete those hours as part of the original agreement?
Yes, Your Honor.
Okay. All right. So you think you get them done by the end of July?
Yes, sir. I can.
Okay. What's the second date, Madam Clerk?
July 23rd, Your Honor.
7/23.
Yes, sir.
Okay. Thank you now. Good day.
You too.
All right. Mr. McKinney or Ms. Yeski?
Judge, may I call Mr. Sean Watson?
Absolutely.
Mr. Watson is present and approaching in two case numbers, 24 CF 1016 and 24 CF 343. We had set today as a continuation of docket day, as a continued docket day to determine whether or not we were going to reach an agreement or go to a trial. The court had had that discussion with Mr. Watson the last time that we were in court. At this time, I have reviewed the case extensively with Mr. Watson, including the state's author, and he has indicated that he wishes to proceed forward with trial. At this time, I think it would be appropriate to put some of the numbers on the record to make sure that it is clear.
All right, go ahead.
As charged, there are a total of 33 counts in 24 CF 10116 and 2 counts in 24 CF 343 with a combined exposure of 430 years. Department of Corrections, I would ask the state, as charged, to put on the record what the current guidelines are.
Yes, the current guidelines, Your Honor, would call for a minimum of 44 years because it would score 733 points.
And the negotiation that we've been discussing in court and outside of court, I'll turn it over to the state, what the state's offer for reduction was.
So the state was offering a plea to unenhanced charges for CP, only 20 counts, 3 counts for failure to register, and 1 count of using a two-way communication device for 146.7 months DOC.
And that was with no probation to follow.
Correct.
All right.
And that has been clearly communicated to Mr. Watson, and it's his position at this point in time that he wishes to reject the state's offer and proceed forward with a jury trial, which would be scheduled in the court's next cycle. But I wanted to make sure, since we're here in court and we're making a record, that the court had the opportunity to discuss anything with Mr. Watson if the court so chose.
And it's the state's intention to revoke that offer and proceed to trial as charged?
Yes, Your Honor.
That is approximately 11.9 years.
And so the agreed upon offer is both as to the registration case and as also to the new possession case, correct?
Yes, sir.
Correct. And the defense has had the benefit of additional discussions with our consulting expert prior to today's court date and making this decision.
Anything further?
No, Judge.
No.
Okay, so the state revokes their offer and matter will remain set for trial.
Yes.
Yes, sir. As to the next court date, I believe is 7/13 for pretrial. Does the court wish to come back to that or come back straight to the next docket day?
Pre-trial, so if we have any intervening matters, we will be able to discuss them at pre-trial.
Yes, sir. Okay, so 7/13, 9 a.m. Thank you, Judge.
Thank you.
Judge, may I call Michael Williams?
Yes, are we expecting anyone else remotely?
I am not, Judge.
The state doesn't anticipate anybody remotely.
Good morning, sir.
Judge, this is Michael Williams before the court. He's here in 26 CF, just keep your hands out of your pockets. 26 CF 241. And I did see that the court had signed an order to appoint Dr. McDonald for an evaluation in 26 CF 241.
Correct.
And I did provide contact information to Mr. Williams related to Dr. McDonald's address, phone number, and that she has availability at noon today, from noon until 2. I believe at this point, Mr. Williams wishes to address the court, because I don't believe he wishes to go to that appointment.
No, it's not. I just kind of, for a possession charge, I just kind of disagree with, I was wondering if we could just proceed without that. I really don't want to be involved with it, or any of the kind of, if the state possibly decides to hand out a probation sentence. The probation gave me before, about 10 years ago, with Bridgestone, I've had a lot of problems with, my aunt works over there, and there's, she's been trying to file Social Security on me, and I just don't really want to, is there some things you can tell me that I could benefit from this? Or, I just don't feel, I feel like it could cost me my job. Is there a way we could proceed without doing that?
Well, let me kind of take a peek at what's going on and see if I can figure out what's happening, and we can have a conversation about that.
Yes, sir. There was I believe...
Hold on just a second.
Okay.
Mr. McKinney, was your motion filed in good faith belief that it was necessary for you to zealously represent your client?
Yes, Judge.
All right.
Can I intercept this real quick?
Well, talk to your lawyer first. Are you talking to me now?
Yes, sir. It's already
Okay.
waiting.
Based upon what the motion was filed and the request that was made, I've signed an order that requires you to meet with the doctor.
Okay.
And you'll be required to do so.
All right. How is that going to affect me in the long term for either probation or possibly jail time?
We don't know until after you meet with the doctor and the doctor says what the report is.
What is that anyway? I just don't understand what that is. Is that,
The doctor's going to meet with you and talk to you about your ability to know and understand and proceed with the proceedings. That's what the purpose is.
okay, so that means that,
Means you need to go talk to the doctor and she'll tell you what it's all about.
okay, how does that affect me in the courtroom?
Doesn't affect you in the courtroom at all.
How does it affect me with some of the like where the state could, I haven't been in trouble in 10 years for a possession charge.
Yes, sir. But, you're getting far beyond what the issue is.
Right.
You need to go to talk to the doctor, and the doctor will give you guidance on those issues.
Well, there's other people in the car at the campground, so.
Yeah, well, we're not trying the case today. Today is not the day we try the case. Today is, we're just here talking about moving the case forward and the requirement that you go and meet with the doctor.
Okay.
Okay.
Is that doesn't mean anything I'm nuts, does it? Just off the record?
Well, there's nothing off the record in the courtroom, sir. And so you just need to go and meet with the doctor, and the doctor will discuss everything with you as appropriate, okay?
Yes, sir.
All right, thank you. Now, good day.
Is it today I have to go?
Yes, sir.
Okay, as far as the next court date, is there any way to get anything besides July?
It's July 13th would be the next court date, but after you go meet with the doctor, come talk to me.
Okay.
And if we need to do anything from there, we can. Okay. So that's where you need to go.
What should I expect on the 13th? Are they going to send it?
Well,
It's a pre-trial.
I guess what he's trying to say is that after you talk to the doctor, we may not have court on the 13th, but if you check with Mr. McKinney, he'll tell you, okay?
Yes, sir. Is that-
Because we may not have the doctor's report by the 13th, so he may ask to have that continued. But you need to contact him after you meet with the doctor, and he'll tell you what to do.
Yes, sir. It could be in my benefit, is what you're saying?
Say again?
It could be.
Okay, thank you. Where is the address?
The address is right here, and they're expecting you at noon. Okay?
Sorry, thank you for your
All right, good day, sir, good day. Yeah. All right, Samuel Strength. All right, Ms. Strength, it looks like you do qualify for the appointment of public defender. I'll submit this application to the clerk. The clerk will tell you whether you do or you don't. If they say you don't, they'll tell you why. If you think they're wrong, get everything you have that shows they're wrong, bring it to court with you next time and share with your lawyer. I'll appoint a public defender to represent you in this matter. Hold on just a second, and they'll step over and help you.
Howdy. Your attorney's going to be Ms. Yeski. Is this an arraignment on the violation of probation?
Yes.
Not available anymore? Mr. Thank you for that, Judge. We did a denial and asked for a court date to be set without subpoenas.
All right. 7:13, okay?
7:13 is
Now,
good trial.
7:16, I keep doing
7:16.
that.
Yes, sir.
Let me write that on the card for you.
Appreciate it.
No subpoenas.
Correct, thank you.
All right, very good. Thank you, Mr. Strength. Get in touch with your attorney and be back in court then unless they tell you otherwise, okay?
Thank you, Judge.
All right, good day.
That's fine, Frank. 10:14.
Got some folks in the gallery we can get about their business. Ms. Yeski and Mr. McKinney, some folks out there.
I don't believe so, Judge.
All right.
Judge, this is Carol Litz in 25 CF 2416. I'm standing in for Mr. Cochran. There is an agreement that's already been signed in this matter for the violation of probation in 25 CF 2416. All right. The agreement.
I've already got over 4 months.
The agreement that I have in front of me reflects an admission to a violation of probation. She will be adjudicated guilty, sentenced to 4 months in the Okaloosa County Jail with credit for all time served with standard court costs. that will revoke and terminate her probation in 25 CF 2416. May I approach with plea agreement?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. And put your hand down. You heard what Mr. McKinney said, but I believe Mr. Cochran has been representing you, correct?
Yes.
Okay. And he tendered a written plea form which claims to have your signature on it. Did you read and sign that?
Yes.
Do you understand that you're admitting the violation?
Yes, sir.
That says, yep, Judge, I violated the way the affidavit report says it did.
Yes.
You understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
And you'll be adjudicated guilty if not previously. Your probation will be revoked and terminated. You'll get 4 months to county jail credit for all time served, $100 cost of prosecution, $150 state-provided legal defense, and I'll give you 2 years after your release to get all your fees and costs.
Yes, sir.
Okay? All your questions have been answered about the plea and how it affects you?
Yes.
You're satisfied with how you've been represented?
Yes, I am.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you very much. Thanks.
Okay, so it stays downstairs. Ms. Oglesby? Judge, this is Cheryl Oglesby before the court in 2 case numbers, 25 CF 587 and 25 CF 1856. She is also represented by Mr. Cochran. Are you okay?
No.
You know it now?
The posture of this case, from reflecting Mr. Cochran's notes, is that she is being evaluated for the 90-day mental health diversion program, and that we would need a status date to determine whether or not she is appropriate for that program or not.
All right.
So I would ask for a continuance for a status court date so that she may be evaluated for that program.
All right, state?
No objection, Your Honor, that's correct.
And I believe this is set for arraignment, but I would enter a denial of the violation of probation.
Have they done their report yet?
That was my question to Ms. Oglesby. I don't believe that they have finished the evaluation to prepare a report at this point. But I intend to reach out to Ms. Cindy Myers and Mr. Cochran to see where she is in that status.
I don't see anything yet. Okay.
I don't believe she's met with Ms. Myers yet.
Okay. So denial, you want to set it short?
If we could, Judge.
All right.
Just to make sure the evaluation is moving forward.
first time in July, and then if it comes in sooner, we can address it?
Yes, sir.
Okay, all right, 7/16. And if it comes sooner, then let us know. And if it does come sooner, then just, you also know that if it comes sooner and the state agrees, then I'll sign the order releasing her to the program without the need for a hearing.
Yes, Judge.
Okay.
So.
Thank you, have a good day.
And this is a long, pretty good. Did you read that through? Is that your agreement?
Yeah, that's fine. This is with credit rate.
This is Mr. Rodriguez Malone in 22 CF 1687. We have reached an agreement and has violation of probation. He is represented by Mr. Cochran. Mr. Cochran did negotiate the agreement. The agreement calls for Mr. Malone to admit the violation of probation. He will be adjudicated. He will serve 11 months, 29 days, Okaloosa County Jail with credit from the last date of arrest, which is March 26th of 2026. Standard court cost of prosecution. This will revoke and terminate his probation in both counts. No objections to the score sheet, which has been provided, which does reflect a total sentence points of 55.9 points, so I believe that this will be an agreed-upon downward departure. May I approach?
That's the agreement, Your Honor.
You may. Raise your right hand, please, Ms. Malone. Do you swear or affirm to testify truthfully in this case under penalties of perjury?
Yes, sir, I do.
All right, you put your hand down. You heard what Mr. McKinney said on your behalf, and you signed the written plea form?
Yes, sir.
All right, according to this plea, you're admitting the violation, is that right?
Yes, sir.
And that says, yeah, Judge, I violated the way that affidavit report says I did.
Yes, sir.
And you understand by doing this, you're waiving the right to a hearing where the state would have to prove your violation.
Yes, sir.
You will be adjudicated guilty if you weren't previously, and you're going to be sentenced to, your probation will be revoked and terminated. You're going to be sentenced to 11 months, 29 days in the county jail credit for time served with a special condition, and that is you're agreeing to credit only from 26 March of this year. So if you've got prior credit, you're waiving that, and that's important because ordinarily, people are entitled to all credit, but the state's offering what you've agreed to is only credit from them. Do you understand?
Yes, sir, I do.
Okay, all right. And then you're going to have $100 cost of prosecution, $100 state provided, $150 state provided legal assistance. And I'm going to give you 2 years after you're released to get all your fees and costs paid, okay? Is that enough time, you think?
Yes, sir.
All right. Mr. McKinney, Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
You're satisfied with what they've done for you?
Yes, sir.
All right, the court will find the plea to be freely and voluntarily entered into as a downward departure based upon an agreed-upon plea bargain. Thank you very much. Good day, sir.
Sir, that's for sir. No, okay, go there. Taiwan Lee. We're going to continue. I'll look it up.
Good morning, Ms. Yesky.
Good morning. Right, first I have Ricky Ramsey.
I'm going to try to set up the next one.
He has not officially been sentenced. Federal plea forms are signed.
He had been sentenced to 16 years.
And while you're waiting, we also have Stephen Pancoast on the docket. That was 25 CF 2136. It was set as a status to ensure that he was transported to Phoenix House, and he has since been transported to Phoenix House.
You got that, Madam Clerk?
Yes, Your Honor.
State agree?
That's correct, Your Honor.
No further settings are required?
Correct, Your Honor.
Won't be sentenced for another 2 months, so we can go down to September. All the plea forms are signed. Okay.
And then additionally, I have Sean Perkins, 26 CF 271, 26 CF 344. He is on the docket today for a violation of probation. However, he is currently being held in Stafford County, Virginia on pending charges and will be held there for the foreseeable future.
Well, and when we're finished with your client that you have, we'll come back to Mr. Perkins at the bench.
Okay, sounds good.
All right.
Your Honor, this is Ricky Ramsey before the court in 25 CF 2456. Your Honor, we are looking for a continuance. I had some discussion with the state about our counter offer to resolve. However, it's looking like this may be a plea to the bench, and I'm looking for some more time to discuss with my client the risks and the plan for pleading to the bench. This is a case where we're looking for treatment over incarceration, and my client also has an eye surgery coming up sometime this month. He has suffered from a retina detachment since he's been at the jail, and they are scheduling that surgery. But I believe if we set it for the next day in July 16th, that should be enough time.
All right. State?
I think the state would just like to set that date with subpoenas, Your Honor.
With subpoenas it is. 7/16 with sub, so that'll be at 2 o'clock.
Thank you.
All right, very good. Thank you, Mr. Ramsey. Good day. All right, and then let's get Perkins at the bench.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I've got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested...
All right. All right, your next case, Ms. Yeski.
Next case, I have Elijah Reed,
Read, please.
24 CF 1756. Yes, he's in custody.
Elijah Reed?
Yes.
And I show 19 CF 3329, you're saying it's 2024?
My apologies. You're correct. 19 CF 3329.
Okay. 130? I have them both on at the 9 and the 1:30.
Yeah, we can just address his case this morning, and he won't need to be here for the 1:30.
You see how that happened, Madam Clerk?
He is a new case, Your Honor.
Oh, I see. Well, we'll have to have him here for the new case then.
Okay.
And the new case is the basis of the VOP arraignment?
Yes, Your Honor. From what I can tell.
We'll just take care of the VOP and the new arraignment when we see him this afternoon, okay?
That works.
All right. See that edit, Ms. Natali?
Next, I have Brandon Rogers. That one is 24 CF 1525. Your Honor, this is Brandon Rogers in 24 CF 1525. If we could have a moment to sign the agreement. Again, Your Honor, Brandon Rogers, 24 CF 1525. We've come to an agreement in his case. It will be to admit the violation, maintain the withhold, reinstate onto probation, modify to add 35 days in the Okaloosa County Jail with credit for all time served, as well as add the additional condition of a substance abuse evaluation and any recommended treatment, as well as extend probation for 12 months, and reinstate all original requirements. That will also include the VOP cost and cost of defense, which I'm going to add to the agreement right now, and we will initial. Your Honor, may I approach?
Granted. Thanks, Ms. Yasi. And do we have a score sheet, or is that going to be coming?
That will be provided at a later date by S.A. Snow, Your Honor.
All right, but the parties agree that the sentence imposed here is a guideline sentence?
That's correct, Your Honor.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you put your hand down. You heard what Ms. Yeske said, and you signed the written plea form?
Yes, Your Honor.
You understand that you're admitting the violation?
I am, Your Honor.
And that tells me, yep, I violated the way the affidavit report says I did.
Yes, Your Honor.
And by doing this, you understand you're waiving your right to a hearing where the state would have to prove your violation?
Yes, Your Honor.
All right. And in this case, adjudication will continue to be withheld. And you'll modify this to 35 days in the county jail with credit for time served. Add a substance abuse violation. Extend the probation. Is that 12 months from the original date of the termination?
Yes, Your Honor.
Okay.
Yes.
So whatever date it was, it'd be an extra 12 months from that.
Yes, Your Honor.
And then you've got to complete all your original conditions that you haven't completed, and you'll have the additional fees and costs that were announced. Okay. Ms. Yeske answered all your questions about the plea and how it affects you?
Absolutely.
And you're satisfied with how Ms. Yeske's represented you? The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you.
Next, I have Jeremy Ross. Yeah. 24 CF 1756.
Hey, Ross. You want that? Ross.
Your Honor, this is Jeremy Ross, 24 CF 1756. If I could have a brief moment. Your Honor, we have received an offer in this VOP case, 24 CF 1756. However, I just became aware that Mr. Ross has a new felony case, 26 CF 1047, and that...
So say again, 26 CF 1047?
Correct, and I believe the arraignment is set for 7/16 in that case. I've spoken with the state, and we're looking to set this on possibly your 6/18 day, and in that case, I can get with the state on getting information and possibly resolving both cases together.
All right.
That's correct, Your Honor. I made a note for ASA Snell, so that way he can file information and hopefully be able to resolve both those cases next Thursday.
Thank you.
Next Thursday?
Next, Your Honor, I have Paul Seelock, 20 CF 2342.
All right. And Madam Clerk tells me that Mr. Seelock has a felony arraignment on the 1:30 docket as well.
Okay, thank you, Your Honor. If we'd like to keep him until 1:30 and...
Well, do we have our informations? We don't.
I can check. You don't see one in the clerk's site?
No, I just mean available so we can do the arraignments, I guess is what I'm saying.
Let me look.
No, I have a printed copy, if you'd like that.
Yes.
Yeah, it looks like an information has been filed in that case. Thank you. In Your Honor, at this time, we would enter a plea of not guilty, waive formal reading, and request that this case run with his other case, 20 CF 2342. And just for the court's awareness,
Okay. Is this Seelock?
yes, and Mr. Seelock is set to possibly...
I've got 23 CF 2053. And the new case, 26 CF 742.
The only case that I have on the docket, Your Honor, and this is just from the notes, is 20 CF 2342. I'm not saying that those other two cases aren't on, but
20 CF
2342.
That's what I have as well. And just for the court's awareness, Mr. Seelock has been referred for the mental health court program in that 20 CF case. And I'll have to get with the state on this newer case, but I believe we can bring all of the cases into the mental health court program. He's been going to mental health court, and this case is set actually for Judge Reed's docket on 6/15. We already have the terms, and I just needed more time to go over the terms with Mr. Seelock so that he fully understands what's required of him in mental health court.
Okay, so we've already entered a denial on the 20 case, and he's being screened for mental health court. Now we've got the 26 case, which we're doing a not guilty plea on,
Yes,
and hoping that it'll travel together.
yes.
It also does appear, I'm looking at the 23 case, this is his case as well, going off of the date of birth, so I think there needs to be a denial in this VOP as well. And I've made a note for Mr. Snell to be able to look at that case when taking into account the offer for all of them.
Can you include Taylor as well, because she's already made an offer from the law?
Okay.
What was that 2023 case, Your Honor?
2023 CF 2053, and then a 2020 CF 2342, and then now the 2026 CF 742.
And so, Your Honor, if we could set this for, basically for status on the 7/13 pretrial date, and we'll work with the mental health court state attorney as well as the state attorney on the case.
All right. Any objections to that?
No objections, Your Honor.
So ordered. And that takes care of both our 9 o'clock and our 1:30. Now, I didn't realize we had those information, so if we want to move back to Elijah Reed and take care of him and get them out of the bin for the jail as well, we can do that. All right.
Still all the money, if you're ready.
Your Honor, this is Charles Stovall, approaching before the court in 22 CF 2612. If I could have a brief moment. Again, this is Charles Stovall before the court in 22 CF 2612. We've come to an agreement in his case. It will be to admit the violation, adjudication of guilt, serve 18 months in the Department of Corrections, and the state stipulates that all time has been served, revoke and terminate the probation, and have 2 years to pay any remaining obligations. That will also be including a $100 VOP cost and a $150 cost of defense. A score sheet will be provided.
That's correct, Your Honor, and the state would acknowledge that it will be a guideline sentence.
If I may approach.
Granted. Raise your right hand, please, Mr. Stovall. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
Okay, you put your hand down. You heard what Ms. Yeski said on your behalf, and you signed the written plea form.
Yes, sir.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And that tells me, yes, Judge, I violated the way the affidavit report says I did.
Yes.
By doing this, do you understand you're waiving the right to a hearing where the state would have to prove your violation?
Yes.
In this case, you will be adjudicated guilty if you weren't previously. Your probation will be revoked and terminated. You'll be sentenced to 18 months Department of Corrections, credit for all time served, and the state stipulates that you have served that time, so this is effectively a time served sentence. You'll have 2 years to pay all your remaining obligations, and you'll be assessed an additional $100 cost of prosecution and $150 cost of state-provided legal assistance. Is that what you understood?
Yes, sir.
Ms. Yeski answered all your questions about the plea and how it affects you?
Yes, sir.
You're satisfied with how she's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea.
Okay. Rodney Swain will be next. 25 CF 777. If I could have a moment. This is Rodney Swain before the court, 25 CF 777. We've come to a resolution in the case. It'll be to admit the violation, reinstate onto probation, extend probation for 12 months, modify all remaining probation to drug offender probation, as well as modify to add completion of the Chrome program, as well as modify to add a 5-year suspended sentence. This will also include a $100 VOP cost and a $150 cost of defense. I have the complete agreement?
Yes, Your Honor, the state will provide a score sheet. This will be a downward departure for the purposes of a legitimate uncoerced plea bargain.
All right. Yes. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under the penalties of perjury?
Yes, sir.
Okay, you put your hand down. You heard what Ms. Yeski said and you signed the written plea form?
Yes, sir.
Do you understand by this plea arrangement that you're admitting the violation?
Yes, sir.
And that tells me, yes, Judge, I violated the way my officer says I did.
Yes, sir.
And do you understand that by doing this, you're waiving the right to a hearing where the state would have to prove your violation?
Yes, sir.
And the sentence you'll be imposed is adjudication of guilt if you weren't previously. You'll be reinstated to your probation and extend your probation by 12 months. And so is that 12 months from his original termination date?
That's correct, Your Honor.
All right, so whatever your termination date was, it'll be a year longer after that.
Yes, sir.
And the remaining portion is going to be on drug offender probation with the condition that you've also got to do the Chrome program. Okay?
Yes, sir.
And there's also a modification for a 5-year suspended sentence, and that's a really big modification. Do you understand what that means?
Yes, sir.
What does it mean?
It means if I violate, I go to prison for 5 years.
Correct. And at least in my view of it is, that's a big jump, because it basically says, you know, I'm sort of the reverse. Instead of giving you keys to get out of prison, I'm giving you the keys to open the door, put yourself in prison. And so that's kind of the last step the state's saying, you know, we're giving you the chance, the one last chance to perform on probation. And if you don't, then you're going to go to prison for the 5 years. You understand that?
Yes, sir.
All right, so it's a big, big difference.
Yes, sir.
And so, and the reason I'm addressing it so much is I don't want to have to send somebody to prison for that. But that tells me that the state believes that this is your last chance to finish probation and do well. Okay? So what I want to see is I want to see around your termination date, you're back here and you're not going. Right? That's what I want to see.
Yes, sir.
And I want to be able to look out in the gallery and say, look, see, Mr. Swain could do it, everybody else can. That's what I want and I hope. And I hope that, you know, that thing back there, thinking about that's going to motivate you to get this done and get complete. All right, so it's not, I'm not trying to threaten you with that, but that's my hope that you understand that that's back there and that motivates you to get it done, okay?
Yes, sir.
Okay. All right, Ms. Yeski answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied with what she's done for you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into, and I'll accept the plea. Thank you now. And good luck, Ms. Swain.
Okay. Elijah Reed coming back before the court.
And we're doing both the arraignment and also doing the two different arraignments. I guess we have the VOP and the new law, correct?
Yes.
Okay. And hold on just a second for your information. I just show the 26,845 and the 19,3329. Is there another case?
Nope, I think that's it. Okay. So at this time, we will enter plea of not guilty, waive formal reading, and we would request, again, to set this to the next pretrial date, 7/13. We will be conducting a confidential mitigation evaluation in this case.
And also denial on the 193329.
Yes, Your Honor.
Okay. All right, 7/13.
Okay.
All right, very good. Thank you. All right, and now clerk says that we had Ricky Ramsey, and he's also, this is not about you, sir, we're something else. You're free to go, yes. We also have Ricky Ramsey for arraignment at 1:30 as well that we didn't cover.
Okay.
I don't know if Ramsey's still back there or not.
Ramsey should be.
All right, so we'll get him, we'll do that arraignment too.
We'll go ahead and pull him out.
Yeah, if we can.
Next, I have Sharp in the feed, Your Honor.
All right, Sharp.
Your Honor, this is George Sharp before the court. In a few cases, 25 CF 1006, 1023, 1025, as well as 1217.
We're here for status, right?
Oh, we're actually here for a competency hearing. I don't believe we actually had the hearing last time, based on Dr. McDonald's report, as well as your order determining him not competent to proceed.
Okay. Thought we did, but okay.
And, yeah, we didn't see that order in the clerk's site, and I also thought that we had addressed it last time, but I believe to go forward with the level 1, level 2 program, we do need that order.
And if you'd approach.
Yep.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview.
Next, Your Honor, I have Mark Stupar, who's in the gallery.
Mr. Stupar, Mr. Ramsey, real quick, we'll just get his arraignment done. Welcome back, Mr. Ramsey. We're just trying to get your arraignment done instead of make you wait till 1:30, okay? And it doesn't look that I see, Ms. Yeski, that you were appointed on Mr. Ramsey's 26 case. You're appointed.
Thank you. Is that the information? May I approach and get the information?
Yes.
Information. Your Honor, we give the information, enter plea of not guilty, waive formal reading, and request that this case be tracked with his other case, 25 CF 2456. We set that one on 7/16 with subpoenas,
All right.
2 p.m.
Okay. Thank you very much.
Thank you. And then we have Mark Stupar in the gallery. This is in 24 CF 2900. And in this case, we set this as a status on the violation of probation. Today, Your Honor, we were hoping to have Mr. Stupar sign the order. This was a situation where there was, the order that was presented to Mr. Stupar was inaccurate, so we were requesting that corrected order, and I believe it has been corrected. Mr. Stupar's probation officer, Officer Brown, was here today, and if actually we could pass this case, so I could talk to Ms. Browner first, get that order so that we can sign it.
All right. So you want to pass for a minute?
Pass for a minute, yes.
Okay. All right, very good.
Thank you.
Hold tight.
Yep, hold tight.
Mr. Lee?
Yes, sir.
Jason McKinney on behalf of Mr. Taiwan Lee, I'm standing in for Mr. Cochran in 24 CF 2903. This appears to be a violation of probation arraignment. And I would note that he has a new case, which is 26 CF 1048. Madam Clerk, do you know what the arraignment date is on that 26 CF 1048?
It looks like that case is set for arraignment July 16th.
What Mr. Cochran is asking for is to enter a denial to the violation of probation and to track with the new case.
All right.
No objection, Your Honor.
It is set for 7/13, right?
7. The new case? Or?
New case.
No, so the new case is set for a pretrial conference of September 14th.
Okay, 9/14. Okay. Track with the new case.
Thank you, Judge.
All right, thank you.
Stay here for a minute, okay? It appears that Mr. McCotter is with us today in 25 CF 7-8. Looks like he's in mental health court. He also has a case in front of Judge Clark that he just went to court for. The ask from Mr. Cochran is to ask for a continuance of this matter without subpoenas so that he can work through those moving pieces.
What's the case in front of Judge Clark?
26 CF 728, Your Honor.
Is that one of the reasons for violation?
Yes.
Okay. Okay, that's fine.
How did it end up there?
I'm not sure, Judge.
Not sure. I think we transferred it because there was a co-defendant that was also being handled in there, and that was probably done in error without knowledge of the VOP.
Yeah, in the 728 case, it said, the motion says there's a co-defendant. And
Yes, sir.
that's the reason it was transferred.
Yes, sir.
So, well, y'all just collaborate the best you can then between the divisions, and let us know if it's more efficient to send these over there.
Okay.
Yes, sir.
Thank you, Judge.
All right. And so which date do we want to leave it on with no subs?
7/16 would be okay with the state, Your Honor.
All right, 7/16, no subs.
Yes, sir.
The case, I don't see where it denied the violation, just like.
Then we didn't have a denial if a denial has not been entered.
All right, denial's entered. Thank you, Madam Clerk.
716, no sign?
Correct.
How are you? How are you?
I hope you don't.
Thank you for that time, Judge. Judge, if we could set this over to next week for, I guess, change of plea. Mr. McLemore's been sentenced federally, and that relates to the 25 CF 1695. That's going to leave one case remaining that needs to be resolved, and I believe that Mr. Cochran and the state can reach that agreement ahead of next week.
That's correct, Your Honor.
All right.
That way you'll get you done.
Give me just a second. My software's having a hiccup here.
Yes, sir.
McLemore, correct?
Correct.
Yes, sir. All right.
And its cases 25 CF 1695 and 25 CF 379.
And the 25-562 is disposed of.
I only have the two cases in
Yeah,
the
I only
document.
have the 2 cases, Your Honor.
Okay.
We'll look into that though and make sure that regardless, it will all be resolved next Thursday, Your Honor.
The federal sentence is in, so it sounds like we need to wrap up the last loose ends.
All right. 618, no subs.
That's the next one. Yes, sir. Next week.
Thank you. Thank you, Mr. McLemore.
Next we have Markel.
O'Neill?
Yes, sir.
Mr. Markel O'Neill is here in 25 CF 2383. I'm standing in for Mr. Cochran. This is on the docket for a bond reduction hearing in 25 CF 2383. And I do have Mr. O'Neill's father in the courtroom that I would ask to call as a witness.
You may proceed.
What's it, Victor? Yeah. Victor? Judge, may I call Victor O'Neill?
Yes.
Victor O'Neill. This address that they wrote in 42 Carson Street in Fort Walton Beach, that's not where you'd be living in Birmingham. Okay, so that's an old address?
Yes, Birmingham House. I mean, auntie is good. If I stay close.
What's her name?
Raise your right hand.
What's your auntie's name?
Swear to affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth.
Yes. Please be seated and direct your voice to the microphone you see there in front of you so we can all hear and understand what you have to say. You may inquire.
Sir, could you please state your name for the record?
Victor O'Neill.
Mr. O'Neill, how do you know Markel O'Neill?
I'm sorry.
How do you know Markel?
He's my son.
Where do you live?
I live in Birmingham, 751 Rose Drive.
How long have you lived there?
I'm 57.
How long have you lived in Birmingham?
I'm sorry?
How long have you lived in Birmingham? Can you hear me okay?
I can't hear you.
Okay.
Do we have a device? Do you need some help with the device?
Yes.
Okay, hold on just a second.
Thank you, Judge. No, that's okay. I didn't know that he needed that. That's okay. That's all right. Too much construction. And Judge, while they're going to retrieve that, may I make some record?
Yes, sir, you may.
It appears that it is a $20,000 cash or professional bond from the reading of the motion that Mr. Cochran filed.
Yeah, I think that came out of the pretrial detention when the state didn't proceed on, and then there was a bond order, I believe.
I believe so, Judge. And it was filed out as a 4-count information with battery by strangulation, count 1, trespass at a construction site, a misdemeanor battery, and resisting without violence.
And I've also been on the 185 days.
I'm going to ask you that, yes, sir. And that appears to be with an arrest date of December 7th, 2025.
Is that better for you, sir?
Yes.
Mr. Avenue, can you hear me better?
Yes.
Okay. Now, sir, where do you currently live?
Birmingham, Alabama.
And how long have you lived in Birmingham?
Probably about 60 years.
If Mr. O'Neill were released on bond, would he be living with you in Birmingham?
He would be living close to me.
And when you say close to me, can you describe for the court where that would be?
About 3 miles, but I still own the house. He'd be living with his twin brother.
Does Mr. O'Neill help take care of his brother when he's out and about?
Yes.
Does he have an aunt that lives in Pensacola?
Yes.
Is he welcome at that address as well?
Not necessarily. She said he's welcome now, but she didn't know how long.
Okay, but if he had to have a Florida address, is that a possibility?
It's a possibility.
Okay. What type of work do you do?
I'm a construction owner and then drive for the city of Birmingham Max Transfer.
And what type of work does Markel O'Neill typically do?
He works for me.
So he would have access to that employment if he were released on bond?
Yes.
Does he have any other family supports that live in Birmingham?
Yes.
Who would that be?
That would be his brother. Also, he's got 2 twin sisters. And his mother, stepmother, sitting in the back.
If the court allowed Mr. O'Neill on bond and allowed him to live in Birmingham, would you be helping with transportation to come to any court dates?
Yes.
Would that cause you any issue whatsoever?
No.
Is there anything else you'd like Judge Stone to know before making a decision on bond today?
Yes. Marquez is a good young man. I thank God for him changing his life, giving his life to the Lord, and also he played professional football, finished high school, and some college. So he is a good young man.
I have no further questions.
State wish to inquire.
Is the aunt that you mentioned that lived in Pensacola, is she the closest living relative to this area?
Yes.
Okay. I have no further questions, John.
No further.
The court has one question for you. In reading the arrest reports and the circumstances, one of the witnesses says that it appears that your son was acting much differently and strange around this event. Do you know what was going on? Was there something that happened?
Yes, in my family, a lot of motorists suffer schizophrenia. And I think that's one of the reasons why he had an episode. He was tested a few months ago by the doctor in Birmingham, and he was listed schizophrenic, but we never finished the course because he was trying to get into coaching football.
All right. Is that something you're going to help him address when you get him back home?
Most definitely, yes, sir.
Okay. Does either the state or the defense wish to inquire based upon the court's questioning of the witness?
Nothing from the state, Your Honor.
Nothing from the defense.
As the witness, may the witness step down.
Yes.
Thank you very much, sir. You may
Thank you, Your Honor.
You're welcome, sir.
Judge Mayor, I call Mr. Markel O'Neill.
You may. Raise your right hand, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, you can put your hand down.
Sir, could you state your name for the record?
It's Marquel O'Neill.
And sir, you've been in jail since December of 2025, is that right?
Yes, I have.
And you've been unable to make the $20,000 cash professional bond.
Yes, I have not been able to make it.
Is it your family that would be helping you post a bond if it were reduced?
Yes.
And you've heard your father testify today. Is it your desire to be released on bond to live in Birmingham around family?
Yes, sir.
Would you comply with any conditions that the court would impose as far as pretrial conditions or anything of that nature?
Yes, I will.
And you would come back for any of your scheduled court dates?
Yes.
Have you ever had any failures to appear to court for anything that you know about?
No, I have not.
You just heard that there was some testimony about some psychological testing. Would you comply with any medical appointments that were necessary to move forward with that type of a diagnosis?
Yes, I will. I was once enrolled in some treatment that I did not finish. It was volunteer, so it wasn't court ordered, but it was about a couple of months, and then I stopped because I was coaching, and it took up most of my time to go in the afternoons. But if the court appoints me to go to a rehab or rehabilitation, I wouldn't mind, I will go.
And if the court imposed no contact with the victim here, would you comply with that?
Yes.
Do you know the address in Birmingham where you would be living?
Yes, I do.
And what is that?
It would be 512 5th Avenue South, if I'm not mistaken. I'm not quite 100% on the address. I can get it from my dad or my brother, but I know it's that one, yeah.
Do you help take care of your brother?
I do.
And why do you do that?
He's disabled. He's handicapped.
Okay. And he's the only person that lives at the house in Birmingham where you would be living?
Yes.
I have no further questions.
State?
I have no questions for the defendant, Your Honor.
What type of bond do you think to be able to make?
Arguments?
Judge, the $20,000 cash professional has been an amount that's been unachievable for the family, for Mr. O'Neill. So we're asking the court to consider reducing that amount to a $5,000 cash professional with any pretrial services that the court sought to make sure that the court was happy with the bond amount. Of course, if any monetary amounts are really going to be put out by the family and the father as for Mr. O'Neill, so I know his request is going to be for an ROR plus any pretrial services, but realistically, I believe the defense is asking for $5,000 cash or professional so that a bondsman is involved in any pretrial services, including no contact with the victim, and any testing or monitoring if the court so sought.
State?
Yes, Your Honor, when looking at the bond or the motion for bond reduction, Your Honor, and then looking at the factors in 903-046, the state would argue that really the only factor that goes for the defendant would be D, would be his past and present conduct. I mean, he doesn't, admittingly, he does not have a history that the state can see. However, when we go into A, B, and C, we feel as though those factors indicate that a $20,000 cash professional bond is a more than fair bond. When we look at the nature and circumstances of the offenses charged on that date, this was a random event where two people who didn't even know the defendant were attacked. One of the victims was being attacked and was being punched. He suffered a laceration on his cheek that an officer described as being relatively deep. His girlfriend or wife at the time then had to pull off the defendant off of him, and then she actually ended up being chased, grabbed, and then was strangled by the defendant. And then he had to be grabbed by the first victim to stop from strangling her. And so this is a very serious event, and we feel like the natures and the circumstances definitely indicate that a $20,000 cash professional bond is more than appropriate. Then when we look at B, the weight of the evidence against the defendant, he then fled from law enforcement. They found him later on in a tree. The witnesses can identify, or the victims can identify the defendant, so we feel as though the weight of the evidence against the defendant is high, warranting that $20,000 cash professional bond. And then when we look at C, the defendant's family ties, the length of residence in the community, there was testimony today that his closest relative is actually in Pensacola. And there was no certain amount of time that he would be welcomed at that home. I'm not saying that's a negative statement, but I mean, we don't know how long he would even be welcomed there. And so now it seems as though he's going to actually leave the area and go to Birmingham.
Well, that's the testimony I understood. He'd be living in Birmingham under the supervision of his father.
Correct. And so the lack of family ties here, looking at 903-046, we understand that this may have been a very isolated incident, but we do feel as though the $20,000 cash professional bond is more than warranted. I also want to put on the record, when we reached out to the victims in regards to this case, one of the victims was almost upset with the state attorney's office for not having charged it higher, because as he stated, there was a moment in time where the defendant threatened to kill one of the victims. And so They are vehemently opposed to any sort of reduction of the bond, and we wanted to make sure that was put on the record.
Nothing further.
The circumstances suggest the court a bond reduction because of the circumstances of the testimony and the support of the family. The fact that the defendant will be living under the supervision of his father and near to his father's home in Birmingham, which I understand is his ordinary place of residence. The court would impose pretrial services with the conditions of weekly reporting by phone, a provision that he must sign appropriate releases for pretrial, to have contact with any provider. He must seek an evaluation and participate in any recommended mental health treatment, and must sign a release for pretrial to have access to that information as well. No contact with any of the victims, not be at or about any place that the victim's residence. I know, at least in reading here, there may be some issue regarding being at or about that place, because it seems like maybe he might have some relation to a child, but the court is not going to change that. If the child lives there, he's going to have to find some other place to exercise his time sharing. I'm not going to allow him to be within 500 feet of that place of residence because of the circumstances presented. And then, so those are the factors under matter 3046. The court would find that it's appropriate to modify the bond. The court is concerned that the contact with the community, that there should be a way for a bondsman to be involved. I will reduce the bonds in the case and make them a $2,500 cash or professional on each count. I think that's just appropriate. That way a bondsman will be involved in the case to help in the fact that the defendant fails to appear with those additional conditions.
I just want to make sure it's clear, because there are multiple counts. The only counts would be 1 and 2, as he was granted an ROR bond on 3 and 4, is that correct?
Right, the count 1, count 2, $2,500 cash or professional each count. The trespassing and the obstruction were already granted ROR based upon the state's stipulation.
That's correct.
All right. So, and he's not to be released until the order's signed, and he has a chance to communicate with pretrial on that question.
Yes, Judge.
Okay. That's reduced.
Thank you. Thank you, Judge.
Thank you. Good day.
Sure.
Matthew Teams, are you?
We'll do it live. We'll do it live. Good.
This is Mr. Matthew Teams before the court. Mr. Teams is here in a number of cases, and I did file a motion for bond at his request. If I go through some of the procedural history in the case, I think that is important to the bond request. In 25 CF 1884, Mr. Teams was out on bond when he had 26 CF 96, 26 CF 95, and 26 CF 94. He's been...
I'm sorry, Judge, to interrupt. Can I speak with Mr. McKean real quick?
I believe that, speaking with the state, it's going to be the state's request to continue this bond hearing until next Thursday so that they may reach out to the victims in the matter.
That's correct. It's my understanding that there are victims that absolutely want to talk at the bond hearing. And so ASA Snell has requested this be heard on June 18th to give us time to get them here.
based upon the state's obligation of the Constitution to consult with and provide the victims the opportunity to be present at each material stage of the proceedings, the court will continue this till 6:18. Should we do it in the morning or the afternoon?
Judge, I think the morning would be fine, but if the state is going to call additional witnesses, that would be the only change in that.
I will let ASA Snell know that if it's going to be an extensive testimony, to make sure that he reaches out to Ms. Natali to schedule that for the afternoon.
All right, because we've got a big afternoon as well, so, but we need to do that, so I don't want to keep folks just in a regular cattle call docket. Okay?
Yes, sir.
All right.
I believe that Ms. Yeski is ready with Mr. Stupar as well.
Mr. Stupar, please.
Dr. Wesley, Mr. Wesley.
Your Honor, this is Mark Stupar before the court in 24 CF 2900. We have the amended order of probation, and he has signed that, as well as Officer Browner has signed it as well. This is the only basis for the violation of probation. Now it's been signed, the amended order has been signed.
State?
This is, can I see the amended order real quick?
Yes.
I just want to make sure.
If the state is not willing to dismiss the violation at this time, we would set it for a contested hearing with subpoenas.
No, Your Honor, at this time, the state is going to announce dismissal of the VOP, given that the defendant has now signed the corrected order for modification of probation, Your Honor.
VOP is dismissed.
Thank you.
Good day. Yeah, you ready, Mr. Callaway?
Judge, yes, sir.
All right, let's take Mr. Callaway's case. What is this?
I'm confused. Are we trying to now change the pre-trial?
So maybe, I'm just going to continue with Your Honor. I just need your signature. Okay. Your Honor, we're asking for a continuance. I got a new offer from the state. I think my client will be interested in that offer. If we could please set this for June 18th.
No objection, Your Honor.
All right, what is the new offer? Just so I'm aware.
Judge, we're looking at the offer, you mean, Judge? It's 1129.
Revoke and terminate probation 1129J.
It's got a nice hold, Judge.
Okay, credit for time served?
Yes, Your Honor.
Oh.
Yeah, of course.
Okay, all right, very good. We'll set it for 6:18.
At 9 a.m., sir?
Yes, sir, no subs.
Your Honor, you know I have a problem on that date. I got Judge Walsh, if I can, I'll let you know now if I can.
Sure. Mr. Callaway, if you could see my note-taking, Ms. Natali says you had contacted her and told her you would be late, so as long as you let me know, I'm okay.
Thanks, Judge.
All right.
That's all I have.
All right, see you then.
June 18th. 18 June, next week, some month.
Good day.
Did you guys have to continue 46? Yes. He was up to vote.
good, it'll take time. There they are, perfect.
That's it for the morning, Doctor.
Wesley, Williams, and Madonia.
Wesley refused.
Wesley refused, Judge, and those are violations of probation, but those cases are also in mental health court. So I'll defer to the court if we just want to continue those on in mental health court. He does have a new law offense, which has got a 716 arraignment.
But do we have new offense case numbers, Mr. McKinney?
I do. It's on a piece of paper that I put somewhere.
If I can approach, I can give it to you.
Okay. You want to just read them for the record?
This is the Wesley case we're talking about.
Yes, sir.
Should have to go to that part here. Okay, so on my docket, I had 25 CF 888.
25 CF 888.
Yes, sir. Violation of probation or arraignment. And I also have that set for mental health court on June 17th.
All right.
He's asking about the new law, which is 26 CF 1038.
Right, and that's arraignment is going to be set on the 1038.
What was 26 CF? All I heard was
1038.
Okay, 1038.
And that has an arraignment date set for July 16th. That's what it looks like from me. And then there's 24 CF 2905.
Correct.
And 25 CF 140.
25 CF 140.
Yes, sir. So the 2905 and the 140 pled into mental health court back in March of 25. And then the 888 case pled into mental health court on July 2nd of 25. And then that would just leave the new law violation of the 26-1038.
All right. So just let mental health court take care of everything but the new charges which are set for arraignment on 7/16.
I believe so, yes, sir.
Yes, Judge.
Okay, so we really don't need to do anything today.
Correct. I believe the court could take the mental health court cases off the docket because they were on the docket in mental health court.
All right. State agrees.
That'd be fine. Yes,
That would only leave us the 2026 CF 1038 case, which is set for arraignment on 7/16.
Correct.
Got it, Madam Clerk? Okay, all right, very good. Thank y'all.
Judge, we have one remaining voluntary. Are you ready for that, Mr. Snell?
But I also show Kyle Madonia. With Mr. Cochran.
And his notes indicate that that is something related to a PTI that's going to happen this afternoon, if we could recall that in the afternoon.
Okay. I had it on for 9, but we'll hear it this afternoon.
Thank you, Judge.
All right, so then that leaves us with Frankie Williams, correct?
Yes, and I believe that Mr. Cochran was going to go through the paperwork with Mr. Madonia, and he knew that he wasn't going to be here this morning.
Okay. Understood. We'll collaborate with that.
Judge, I have Hey there. Judge, this is Mr. Frankie Williams. He is before the court in 25 CF 1737 and 25 CF 1735. Did the court have the benefit of the bond motion?
Yes, sir.
And this is one of those cases where we have had a pretrial detention hearing. There is a pretrial detention order in each of these cases. And during the case, there have been additional bond factors through witnesses that have been presented to me from Mr. Williams that wish to be heard by the court. So, and there have been numerous pro se motions that I have not adopted. So I'm asking the court to consider a motion for bond, understanding that we clearly know that there is a pretrial detention order that is in place in 1737 and 1735. All right. So we would ask the court to proceed forward with the bond hearing.
You may proceed forward.
Judge, I would ask us to call Mr. Williams' mother first.
Granted.
She is present and approaching in court.
Good afternoon. If you remain standing and raise your right hand so the clerk can swear you in. Madam Clerk.
Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes. Please be seated and direct your voice to that microphone you see in front of you and speak up clearly and distinctly so we can all hear you and understand you. Is that okay? Okay. All right. Mr. McKinney, you may inquire.
Thank you. Would you please state your name for the record?
Vernell Williams.
And how do you know Frankie?
That's my son.
And if Mr. Williams were released on some sort of a bond, would he be living at 940 Ashley Lane, apartment J in Fort Walton Beach?
Yes, sir.
Who lives at that address?
Me and my other son, my other disabled son.
Okay. When Mr. Williams is out in the community, does he help you with your day-to-day life?
Yes, he's a big help. I need him.
And what type of work does he normally do?
He's going to start construction with my son-in-law if he were to be released. And I don't have much money, but I have $100 I can give toward his bond.
Okay. I have no further questions from the defense, unless there's anything you'd like Judge Stone to know that I haven't asked.
No, I'm going to have to help my son back up here.
Okay, hold on just a second, see if the state has any questions.
I don't have any questions.
All right. Thank you very much.
Mr. Williams' brother wishes to testify.
Yeah.
Where did he go? Yeah, who do you want me to call next? Okay. Who's that?
That's my brother.
Oh, yeah, there you go. Judge, I'd ask to call Mr. Williams' brother. He is disabled, so that I would ask for some leeway and time for him to get to the witness stand.
Sir, if you wish, you can pull a chair up and he can sit right next to the lectern if that works for you.
That will work better, Judge.
All right, very good. Just have him seated right by the lectern there. We'll put him right there, as easy, wherever it's easiest, okay?
Yes, sir. It might be easier if he stood at the lectern.
Okay.
Yeah.
Okay.
All right, raise your right hand, please, if you can. All right, Madam Clerk, swear to witness.
Do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
You can hold on to this, that's okay. Would you please state your name for the record?
I'm Muhammad Williams.
And how do you know Frankie Williams?
That's my little brother.
And where do you live at, sir?
I'm at 940 Ashley Lane right now.
And if Mr. Frankie Williams were released on bond, would he come live with you at that apartment?
Yes.
When he is out, does he help you in your day-to-day life?
Yes, he do.
Is there anything else you'd like Judge Stone to know before he makes a decision in whether or not to allow a bond or not?
That we need him home.
Okay. I have no further questions.
No questions, Your Honor, from the state.
And who would your lawyer be? That would be
Mr. Brown.
Judge, may I call Mr. Brown?
Yeah.
Good afternoon. Those remain standing and raise your right hand for the clerk to swear to you, please.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you.
Please be seated and direct your voice to that microphone you see in front of you. Is that okay?
Yes, sir.
All right, Mr. McKinney, you may inquire.
Sir, could you please state your name for the record?
My name is Anton Brown.
And how do you know Mr. Frankie Williams?
I'm married to his sister.
And what type of work do you do, sir?
I'm a small-time business owner. I do concrete work, construction.
And you do, how long have you been doing concrete and construction?
Most of my life, about 20-something years.
If Mr. Williams were released on any type of bond conditions, would he be able to work with you in your business?
Yes, sir. He'll start with me immediately.
Would that be full-time employment?
Yes, sir.
I have no further questions.
State wish to inquire. No, sir.
Is there anything else you want Judge Stone to know? I apologize.
No, sir. That's it.
Okay. Thank you. All right.
You're welcome, sir.
Father? Yeah, my father. What's his name? Mr. Musgrove? Who's it?
All right, good afternoon. If you're going to stand and raise your right hand for the clerk to swear you in, please.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Please be seated and direct your voice to that microphone and speak clearly and distinctly so we can all hear and understand you, okay?
Okay.
All right, Mr. McKinney, you may inquire.
Sir, could you please state your name for the record?
My name is James Musgrove.
And how do you know Frankie Williams?
That's my son.
And what type of work do you do, sir?
Right now, I'm on disability.
Yes, sir. And Frankie, we're out on some sort of a bond. Do you believe that he will be going to work?
Yes, sir. He'll be going to work immediately, but he also, you see, he helps out a lot with his brother. I mean, it's a lot better when he's around. His brother get better care. Get better care, you know. He takes better care of his brother than all of us, and that's the truth. We need him home. If we can, I just want him to have a fair, I want him to have just a fair, like a bond, like, other people out. He want to come home. We want to bring him home. We haven't got no lot of money, but we need him home.
Thank you.
State wish to inquire.
No, sir.
All right.
I have no further questions.
Thank you. Thank you, Ron.
Yes, sir.
Gentlemen, may I ask a few questions of Mr. Frankie Williams?
You may, sir. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir, I do.
Okay.
Mr. Williams, could you please state your name for the record?
Frankie Williams.
And you've heard the testimony here today. If you were released on some sort of a bond, would you be going to work doing concrete and construction?
Yes, sir.
And would you be living at the address that we discussed here in court, the 940 Ashley Lane?
Yes, sir.
And obviously, the court can see that you have extensive ties to the community and family. Is that something that you intend to help out with if you were out on bond?
Yes, sir.
Does that include your brother?
Yes, sir.
How long have you lived in the area?
37 years.
I have no further questions from Mr. Williams.
State wish to inquire.
No, sir.
Anything further, Mr. McKinney?
Not as far as testimony, just argument.
All right. Anything from the state?
Nothing from the state at this time.
All right. Arguments.
Judge, Mr. Williams has 2 case numbers. He is charged with trafficking and fentanyl in each of those case numbers. The court did hear a pretrial detention motion. The defense did not have the benefit of the testimony that we put on today in full. At the time of that hearing, we're asking the court to consider that testimony in allowing Mr. Williams a bond, which would effectively vacate the pretrial detention order. That is a relatively new framework, and that is why the defense is requesting this as a motion for bond. There are a number of depositions scheduled, which are referenced in the motion. We did get and receive a lion's share of the discovery, which does show that in one of these cases, Mr. Williams was not in the hotel room at the time that the search warrant was actually effectuated. And I'm not going to get too far into the facts of the case, but we have received the discovery from the state to move forward with the depositions at this point, and that is the posture of the case.
All right. State.
Judge, we had, in this case, we previously had, Mr. McKinney alluded to the pretrial detention hearing, and there was testimony by all law enforcement officers that went over in detail the length of the investigation prior to obtaining the search warrant for both cases, and then actually what happened during the searches. It was discussed at the hearing where Mr. Williams was located during the search. In both instances, the hotel rooms were surveilled by law enforcement for lengthy periods of time. The hotel room was rented by Mr. Williams. No other person was seen going in or exiting other than Mr. Williams. This case, the court heard, involves a lot of fentanyl in the distribution in our county. It was determined that it was a dangerous crime. The problem was beyond a reasonable doubt that he probably committed the crime based on the evidence that was given. The court determined that the least restrictive, or there was no other form of bond condition that could protect the county or our citizens, this area, from the defendant continuing on with the distribution of narcotics. And I do feel, I understand There's family needs, but they're totally separate from the facts of what caused us to be in this position and what the basis for the no bond was about. The facts that the court considered is why there's no bond set in the case before the law, and the state believes that the court should deny the motion for establishing bond.
Well, Mr. Chanel, help me, refresh me here. My understanding was there were two separate incidents, is that right?
That's correct, yes, sir.
And just to be sure, there was one, I think, in April, and there was testing, and the testing came back showing what the substance was. But there was also a separate warrant which resulted in the discovery of substances separate from the April. Is that correct? Is my memory correct about that?
Yes, they were in one. The search in one led to information that for the second one. But yes, they are two separate events.
Mr. McKinney, based upon the court's questions, if you have further arguments, the court will entertain them.
Judge, in the 1735 case, the substances were sent to DEA, and from my best review of those reports that were provided by the state on 5/22 of this year, it looks like I can see about 12-ish grams of fentanyl. He is charged 14 to 28. We do have depositions scheduled for that. I don't want to, we're not here for anything else at that point. And then that is the case where law enforcement entered into a hotel room and located those substances that were sent up for testing. There is the additional case where I believe law enforcement was actually there at a hotel room for another individual by the name of Aubrey Joseph, which resulted in collection of narcotics with FDLE zeros 18.5 grams of fentanyl. So it looks like one of those was in April of 2025. And then the search warrant related to the hotel room related to Aubrey Joseph occurred in September of 2025, in which Mr. Williams was located inside the hotel room in that case. In the first case, it appears that the warrant service was that Mr. Williams was outside the hotel room walking around, I believe, the day's end. So factually, I believe that is what we're looking at as far as grounds for the two trafficking and fentanyl cases, and we are developing that through the discovery process now that we have all of that discovery as of, I believe, May 29 in the 1737 case, and we're proceeding forward with depositions.
So let me restate. After your review of the body camera from the April 28th incident, the addendum probable cause says that the defendant was observed lying on the bed. And you're saying the body cam says he wasn't there.
In April is the one where I believe law enforcement does a search of the hotel room, and Mr. Williams is located inside the hotel room. In September, I believe there was a warrant service that related to that, in which case, in that case, is when he is not actually in the hotel room when they search the hotel room.
Right, the 9/18 probable cause says that they executed the warrant. The room was registered to the defendant.
Correct.
And the defendant had been observed by law enforcement entering and exiting the room.
Correct.
No one else was observed entering and exiting the room, but no one was found in the room at the time the search warrant was executed.
Correct.
And he was in the parking lot of the hotel. He had watched him leave.
Well, but I don't know about that. That's not what I see in the addendum.
Well, that's what I believe the testimony was at the hearing, was that they had people, law enforcement surrounding the area and watching them come through.
Based upon that timeline, anything further, any arguments further?
No, Your Honor.
And what are you arguing is an appropriate bond condition, Mr. McKinney?
Judge, we're asking for the court to consider, since Mr. Williams has been incarcerated since September, that a $5,000 cash professional bond in each case, with any pretrial services that the court would so choose to impose to ensure that Mr. Williams is just going to work and doing nothing else. If that includes some sort of community control type sanctions, I know we call it different things these days in pretrial services, or house arrest sanctions, that's effectively what the defense is asking for.
Anything else from the state?
The state believes that no bond is appropriate. He had law enforcement contact in April with fentanyl possession with him, beside him, and then after that, he continued with the same course of conduct and all the way into September, and it was, they were still, this didn't deter any of the conduct, so I believe no bond is appropriate in the case, Your Honor.
Anything else?
No, Your Honor.
Yeah. But just reading my notes from the hearing, reading my notes from the circumstances, the court's principal concern is the repetitive criminal behavior after a significant arrest and encounter with law enforcement in April, the exact same alleged pattern of behavior of a substantial amount of the hugely dangerous drug as defined by the legislature and as compelled by the legislative direction of the court. The court finds that the bond remains appropriate. Now, as you begin your discovery and you see there's substantial differences, Mr. McKinney, you know I'm not that you get one chance kind of judge. So if you see that there are significant deviations from what the addendum of probable cause says, that's the reason I inquired based upon what you said. I wanted to be sure that I understood what the facts were. If they develop to be different and you're able to challenge that factual basis, I'll listen to that.
Yes, sir.
But based upon that, I don't believe the change in the bond condition is appropriate.
Thank you, Judge. Thank you, Judge.
So that takes us then to, we're ready for McClovich?
He refused, Judge.
He refused? Okay. All right, and he doesn't have a lawyer, he does. I couldn't really...
It would be me, Your Honor. Attorney Chris Cotter on behalf of Mr. McClovich.
Okay, were you appointed, or?
From my understanding, I was. I have a file. It's in my system.
All right, well, let's take a peekapoo at that and be sure we are, in fact, because mine says no, but as we've learned recently,
never know.
They're just trying to keep our brain cells active by challenging us.
I'm challenged enough, Judge.
Indeed. All right. You were in fact appointed at first appearances, so I'm not sure why. So it says no.
I'm not sure either, Your Honor, but I do have a file here. It's my understanding that he did refuse. For that purpose, we would ask for a defense continuance, but I would ask that because information has not been filed, this does not count towards a speedy waiver.
Well, no, we're only here on the pretrial detention.
Yeah, but we are asking for continuance, so I just wanted to make sure that because we're asking.
Of the pretrial detention?
Yes, Your Honor.
Okay. So to be clear, although I know there's no controlling case law, and I think you're referring to the case which is presently going up in the 4th DCA, where the defense moved for a continuance and the state has said something to the effect of, aha, you asked for a continuance. This court does not believe that a request for a continuance of pretrial detention motion has any impact on the issue of speedy trial. The pretrial, so be clear, this court's view of this. The pretrial detention motion is a specific creature of the statute and the rule, and the court does not believe it has any impact on the speedy trial issues. It is only when you're asking for a continuance of the procedural aspects of the case moving towards trial that it implicates the issues of speedy trial. The pretrial detention is essentially an extended, this is the way this court views it, is an extended bond motion. And a request to extend a bond motion, the court just doesn't understand from a legal materiality point of view how that could ever implicate a speedy trial issue. But I understand that
yes, Your Honor.
My rulings are not precedential.
Yes, Your Honor. I just wanted to put that on the record.
Well, I understand, and from my point of view, it doesn't have any impact on it.
Thank you, Your Honor.
And so 618, you think it'll be good?
Yes, Your Honor, and I'll go out there and talk to him. And Your Honor, before we break, as a friend of the court, there's a Mr. Demetrius Simmons. He's listed as being appointed to us, but I don't think he has been. He's been here all morning. He's on the 1:30 docket. I went ahead and had him fill out an affidavit to be, for us to be appointed.
I showed him as you.
Yeah.
Well, actually, Mishieski.
Yes, Your Honor, our notes say that he wasn't appointed. He doesn't believe that we were appointed, so just to be safe, we went ahead and did the affidavit.
Absolutely. And so he's on the arraignment docket, is that right?
Yes, Your Honor.
Good afternoon, sir. Good afternoon. Just give us a second so we can get all that stuff in line.
No problem, no problem.
Thank you. Yes. All right, so you check that you have cash in the bank, but you didn't put how much. You don't have to tell me. You can let your lawyer fill that out.
How much is in there?
Yes, sir, because if you even miss one blank, the clerk's going to reject your affidavit. I like to say because she's mean, but no, it's because the law says she has to.
Put an amount right there. And then right here, is that a yes or a no?
That's a yes.
Okay, put the amount.
Yeah, the judge did not appoint at first appearance, so I'm not sure why. Do you have another case, Mr. Simmons, that you're aware of?
Or do not. Do or do not expect. Yep. What was your question?
Does he have another case possibly?
Not that I'm aware of.
Okay. All right, is that the same account on both sides?
Yes, sir.
Okay, so we don't list it twice, because then the clerk will count it against you twice, so it's just the one account?
Just one account.
Okay. And is that where you pay the bills out of?
Yes, sir. Yes, sir.
All right, and so that's the balance today?
Yeah.
Okay. that you do qualify, I'll appoint the public defender to represent you, okay?
Thank you.
All right. Ms. Yeski.
Yes, Your Honor, and is that the information? Thank you. Here's the information, these are the charges against you. Your Honor, at this time, we acknowledge receipt of the information, enter plea of not guilty, and request this be placed on the next pretrial date.
All right. Madam Clerk.
It looks like it's currently set for the September 14th pretrial.
If we could just leave it on that pretrial date then, that works.
All right, set for 9/14. Yeah, stay in touch with your lawyer and be back in court on 9/14 unless they tell you to be back sooner, okay?
I'll call her in the morning.
Okay, thank you, good day. All right, unless there's any more confusion that we need to unravel, we'll be in recess for 1:30.